That knock at the door, the email asking to bring an animal into your no pets rental. And suddenly you're navigating a minefield of California housing laws. Is it a pet? Is it an assistance animal? What can you really ask? Getting this wrong means serious legal trouble and hefty fines. So today we're cutting through all that confusion around assistance animals. Hey everyone, I'm Jeremy Higgins. I'm with True Haven Property Management. We serve Davis, Woodland, Sacramento, Eastern Solano County areas, and all the little areas in between. And today let's tackle a fair housing topic that honestly causes a lot of confusion and stress for California landlords, and that's assistance animals. That moment when a tenant asks to bring an animal into your no pets property because they say they need it for a disability. Well, what can you do? What can you actually ask? And getting this wrong is a big deal, and it can lead to a serious fair housing complaint or lawsuit. The absolute first thing to get straight based on state and federal law is verified assistance animals are not legally considered pets. Think of them as a reasonable accommodation. Your normal pet policies, any pet rent you might charge, or specific pet deposits, they just don't apply here. Now, where I see a lot of confusion is understanding the difference between the two main types of assistance animals. One, you've got service animals. So under the ADA and California law, these are actually dogs, sometimes miniature horses, and although I can't say that I've ever actually seen one requested in a rental, the key is that they are specifically trained to do work or perform tasks for someone with a disability, like a guide dog or an allergy alert dog. Now, for landlords, here's the critical part about verification. If the disability and the task that the animal performs are obvious, well, you generally should not ask any questions or demand documentation in any way. If the need isn't obvious, well, the law is very strict. You can only ask two things. One, is the animal required because of a disability? Two, what specific work or task has the animal been trained to perform? That's it. So, emotional support animals, these are otherwise known as ESAs. This is where things get a little trickier. ESAs provide comfort or support that helps with symptoms of a person's disability, but they don't need specific training. Because the disability related often isn't obvious, the verification process is a bit different. And here's where landlords often get tripped up, thinking one of two wrong things, really. Either that you can never ask for documentation, that's not really correct, or that you always need documentation. Neither is right for an ESA. Here's the correct process. Only if the tenant's disability and their need for an ESA are not obvious, you can request reliable documentation, but only two very specific points. Does the tenant have a disability as legally defined? And then two, does the animal provide assistance or support directly related to that disability? That connection, that nexus, it's important. About the documentation, landlords rightfully worry about fake letters that are bought online. We've all heard of that. And while it's a challenge, you should look for verification from a reliable source. This typically means like a California licensed health professional, a doctor, a therapist, psychologist, who has an actual treatment relationship with the tenant. In fact, California law in AB 468 put rules in place for professionals issuing these letters, requiring an established relationship. And it was precisely to make those questionable online certificates less reliable. So focus on legitimate documentation from verifiable, licensed California professionals. You absolutely cannot demand to know the specific diagnosis. You can't ask for detailed medical records. You can't require any kind of certificate or ID for the animal or demand any proof of training. So let's quickly recap some of the critical do's and don'ts. Do take every request seriously and respond reasonably promptly. Don't demand documentation if the disability and the need for the animal are obvious. That's a key point that many folks unfortunately miss. Do engage in a conversation, an interactive process. Don't ever charge pet fees, pet rent, or pet deposit for any verified assistance animal. And remember, they aren't pets under the law. The tenant is still responsible for actual damage that the animal causes us, so be aware of that. And then don't ask intrusive questions about the tenant's specific disability. Following these rules is essential for fair housing compliance, and violations can lead to very significant penalties, so be very, very careful there. Our free essential guide to rental property success covers these fair housing principles and the reasonable accommodation process in more detail. It helps make sense of these often confusing situations. So handle these requests knowledgeably and compliantly. You can download this free guide using the link that's below. I'm Jeremy Higgins with True Haven Property Management. Thank you for watching, and I hope this helps clear things up a little bit. Take care.